So I'm going to start out by talking about three different ways that the guidelines are used today. And Robin spoke of each of these a bit, but these 18 years later, these are still ways that we are using the guidelines successfully. One of those is setting standards for counsel who are being appointed in a capital case, making sure that they have the qualifications and training necessary, and ensuring that the responsible person or group that is appointing the lawyer screens those lawyers to make sure they have the right qualifications. The second way is to monitor attorneys who are actively working on death penalty cases to ensure they are meeting the performance requirements that are set forth in the guidelines, that they are doing those things that Robin talked about to ensure that they are investigating the case properly and presenting it effectively to the judge or the jury. And the third way is to enable those lawyers to seek financial and expert resources to assist them in their representation of their client. All of these different ways that the guidelines are used requires some sort of acceptance or buy-in from the responsible group, and that's often a judge or an agency within the state. Because of course, even though we have a federal national death penalty, the large use of the death penalty, the majority of it, is used at the state level. And so we do a lot of work state by state, trying to convince each individual state to accept these guidelines and to make them a part of how they administer the death penalty. And so the next several slides that I'm going to show you will show how in different states we have achieved this goal of getting the state itself to accept the guidelines and make it a part of its own law. It's important to realize that even though the American Bar Association has adopted these as its own policy, as Robin said, that doesn't give them the force of law in the United States. That simply makes them a recommendation of a respected body of lawyers that has vast amounts of experience and diverse viewpoints. And so that gives them credibility, but it doesn't make them mandatory. And so that's why what I'm about to talk about in terms of the work in the states has to be done. So just to set the stage here, this is a map of the United States showing in gray the states that still potentially use the death penalty. The states that are in black are states that have abolished the death penalty, and so we do not currently work in those states. And this is as of June 2021. In the states here that are highlighted in green, and I should say there's 27 of the 50 states that still retain potential use of the death penalty. And of the states highlighted in green, these are states that have adopted the ABA guidelines through legislation or agency rule. And so these states have voluntarily looked at the guidelines, agreed that they have that they are credible and that they will improve the quality of representation in cases, and have decided to adopt them into their own laws. So this is one of the most meaningful ways that we can give the guidelines force of law, is when the states incorporate them into their own rules or laws. And this has been, in many cases, extensive work that has been done with the lawmakers in the state or with the agencies in the state to help them understand how they can use the guidelines to fit within the way that their own death penalty system operates, because every death penalty system in the United States operates somewhat differently from state to state. And one of the beautiful things about the guidelines is that they really are flexible enough that they can apply in a state like in the Mountain West in Idaho or in the Deep South in Georgia. They are flexible enough that those states still can take the guidelines as a whole and say they apply to our lawyers too. So we have 6 states that have adopted the guidelines in this fashion. In addition to that, 5 states have adopted the guidelines in whole or in part through the decisions of state courts. And Robin mentioned one of these, which is Arizona. And this is another very meaningful way that the guidelines can be adopted, because once the state court rules that the lawyers have to comply with these standards, then there's a way to enforce it. If the court has made this decision, then if a lawyer doesn't comply with the standards, the court is there to step back in and say, this has to happen, that you either need to improve your performance or be replaced on the case. So we have these 5 states that have made these proclamations. There is a downside to this, though, and that is, as the justices on the courts change, often the court rules change a bit. And we have seen that, unfortunately, in Ohio, where at one point the guidelines were a mandatory part of the court rules and then later became only a discretionary or optional part of the court rules. So this is something that is something to be aware of when trying to implement the guidelines or a set of guidelines within your own system, is that it isn't just a one-way movement where you can get the guidelines adopted and then walk away and never have to work there again. That it's an ongoing process of reminding the courts and the lawmakers and the lawyers that the guidelines are important and continue to be relevant. In addition to this, we have 3 states that have explicitly adopted the guidelines through a statewide public defender office. And this is another terrific way to give meaning to the guidelines that does not require a court to adopt them or for them to be written into the laws. Where you have an office that provides the representation for most of the state, if that office decides to adopt the guidelines as its own and require all of its lawyers to comply with the training requirements and all of its lawyers to comply with the performance requirements, to do the necessary investigation and retain the necessary experts, then you see the guidelines being put into effect even where they aren't required to be put into effect. So we have these 3 additional states where that has been done. And I will say there are probably numerous additional offices that have done the same, but have simply not made a public statement that they are doing so. And then finally, we have bar associations, state bar associations, that have adopted the guidelines and have used their influence to say, yes, we recognize these are a national set of guidelines, but they also apply in our state. And one of the most meaningful bar associations that has done this is Texas. Texas, I believe, is probably world famous for its use of the death penalty. It used to be the highest use death penalty state in the United States. And the Texas State Bar adopted a set of guidelines that it called the Texas Guidelines for the appointment and performance of counsel in death penalty cases. And it is word for word the ABA guidelines. And we are happy to have that happen. We are happy for them to put their name on it as a Texas set of guidelines to guide lawyers in that state. And that gives them some additional credibility as well in a state that likes to be very independent and think of itself as being different than the rest of the United States. Even though they are the exact same guidelines, having a more local group here, the State Bar, give their approval to the guidelines goes a long way to giving them credibility to local and state judges. And that's what has been done in Texas and also in California. I add one additional state here, Nebraska, where we have legislation that is pending. This is really bringing us very up to date. This was pending before the pandemic started, and I hope we will be able to pick up on it once things start to return to a bit of normalcy here, that we are continuing to push for legislative adoption by law in a state-by-state fashion. Idaho is the most recent state that we did so in 2018, and Nebraska is hopefully next on the list. So this leaves, as you can see, a number of states where the guidelines have not been adopted or implemented in any formal way. Fortunately, we're covering here a lot of the higher use death penalty states, but there are other states like Florida and Tennessee, which use the death penalty very frequently and have large death rows where they have not adopted the guidelines. And so this is showing that we still have a lot of work to do to get the guidelines fully implemented and with the force of law throughout the United States. One of the additional ways that we use the guidelines is to challenge errors by previous attorneys in death penalty appeals. We have the option in the United States, or the opportunity, I should say, in the United States of appealing death penalty convictions through the courts, through both our state system of courts and then our federal system of courts. And the guidelines are a critical tool in showing that the previous attorneys, the trial attorneys, did not meet their professional obligations. And the good news, this map looks a whole lot better than the previous one I showed you. And this shows courts that have recognized the ABA guidelines as a reference point for evaluating the performance of counsel. So this is virtually all states that actively use the death penalty are looking, their state courts are looking to the guidelines as a point of comparison when looking at trial counsel's performance to see, did counsel do what they were professionally obligated to do in this case? And if not, then there is the possibility that the death sentence will be reversed and the case will be sent back for a new trial. This is representing the state court system. Our federal court system, every federal court in the United States has recognized the guidelines as a point of reference. And that has a lot to do with what Robin mentioned, that our state Supreme Court, or excuse me, our national Supreme Court, the US Supreme Court, has recognized the guidelines as representing the standard of care for capital defense. One of the things that my project does is track use of these guidelines in the courts. And as of right now, we have more than 500 state and federal court opinions in death penalty appeals that have used these guidelines since 2003. So that's a remarkable number of cases that have benefited from the guidelines and their use as a benchmark for capital defense performance. And the final way that we continue to use the guidelines today is in training. And Robin mentioned this, that as a part of both the requirements for training and at those training conferences themselves, our capital defense guidelines play a prominent role. The guidelines are an essential part of all of our regional and national capital defense training programs. And there are sessions where the guidelines themselves are taught, but the other training programs also seek to comply with the guidelines to meet the requirements in the guidelines, that there's specialized training in things like mental illness, in forensics, in science. And so the guidelines form a framework for ongoing training for capital defense lawyers in the United States. And the wonderful thing about this, just like having the guidelines used by a statewide defender office, is that this doesn't require a change in the law. This doesn't require a state to adopt the guidelines. every training program in the United States can freely choose to use the guidelines, and the vast majority of them do. And this really makes a change at the individual lawyer level. We're improving the quality of representation lawyer by lawyer in the United States by making sure that the lawyers representing prisoners prisoners on death row and defendants facing the death penalty have the right skills and background to provide effective representation to their clients.